Hello, my name is Richard Karmel and I am Head of Human Rights Reporting at Mazars. Several years ago, the United Nations recognised that if human rights were to be promoted globally, they needed to enlist the help of the corporate world. When this was first promoted by the United Nations, it was suggested that human rights legislation for corporates should be enshrined in law. Not unsurprisingly, following lobbying by business, many individual countries disagreed with human rights becoming law, principally around the potential for a huge upsurge in litigation. However, agreement was able to be reached in having a set of guiding principles which it is hoped over time would become best practice in the corporate world. This debate was taken forward by Harvard professor John Ruggie as Special Representative to the United Nations General Secretary. In 2008, the United Nations accepted his notion of corporate responsibility to respect human rights. In 2011, this resulted in the United Nations endorsing his 31 guiding principles in the Protect, Respect and Remedy framework. So what can global corporations do to address this issue? To demonstrate, we have focused on corporations within the extractive industry, but actually they can be applied to any international corporation. Currently, it would seem that only the largest corporations within the extractive industry have begun to address and report on their human rights obligations. Given the comparatively recent onset of instant global communication, it is not in the interest of any corporation to ignore their obligation as regards human rights, particularly the way best practice is evolving. At Mazars, we believe that it must be in the interest of socially responsible international corporations to undertake the following: implement basic human rights policies and procedures, publicise their human rights achievements, and receive some form of independent assurance to corroborate their findings. The benefits of receiving such assurance are sixfold: access to new markets, consumers and investors, a more sustainable profit stream by looking after local communities. For companies looking to IPO, it will potentially address an important issue head-on, resulting in a greater attraction to the IPO. A reduced risk of share price falls for quoted companies through the reporting of human rights abuses, mitigate the risks of brand and reputational damage for all companies, and through the implementation of appropriate policies, it will lead to a happier workforce. The extractive industry has for too long, and not without some merit, received poor publicity in this area. We see so much good now being undertaken in the extractive industries that we feel it is important for those compliant companies to separate themselves from those companies who continue to abuse human rights. We believe that since the onset of the global financial crisis, the world is looking for a more socially acceptable form of capitalism, and that the extractive industries can lead the way in this area. Our vision is threefold. Investors will only want to invest in companies which can demonstrate their compliance with human rights. Customers will only want to buy from such companies. These companies will only want to solicit goods and services from suppliers who can demonstrate compliance with human rights. In order to implement a human rights policy, it is necessary in the first stage to address Principle 17 of the United Nations framework, that of undertaking human rights due diligence. Corporations should initially undertake this form of risk assessment in order to identify areas where there is a potential for human rights abuse. This risk assessment should result in the following: the implementation of risk control mechanisms early in the process, the setting up of procedures such that ongoing risks are monitored, and the implementation of procedures for identifying new risks. It needs to be borne in mind that by undertaking due diligence does not necessarily mean the corporation will comply with the principles. What it should help identify are the preventative measures in place against the potential for violation of human rights. The second stage will involve the implementation of dedicated human rights policies into the standard operating procedures of the corporation. These are not only to identify and prevent human rights abuses within the corporation, but to simultaneously identify human rights abuses committed by others. These procedures will both maximise a corporation's respect for human rights whilst minimising the financial risk. This should also be summarised in the corporation's Human Rights Charter. The third stage will be for the corporation to engage with an independent assurance provider to undertake an audit of those procedures. These findings should be addressed in a report likely to be included in the corporation's annual report. This human rights audit report should be of great interest and reassurance to all stakeholders in the corporation, be they employees, customers, suppliers and investors.